I'm saddened to announce that the investigation has revealed that Orrin and Orson West are deceased. The investigation has also revealed that they died 3 months before their adoptive parents reported them missing. While the defendants in this case, Trezell and Jacqueline West, are presumed innocent, the securing of a grand jury indictment is a major step in ensuring that there will be justice for Orrin and Orson.
On the docket tonight, the case against the Wests. These are the adoptive parents of the Cal City Toddlers, Orrin and Orson West. They have not been found, but their parents have been accused of their murder. And we've been covering this story for a long time now, but just recently the indictment came down and we heard from the DA. The DA was speaking out. Well, now we've heard from the defense team, and the defense going on the offensive, going after the district attorney. Let's take a listen.
Last week, our clients, Mr. and Mrs. West, were arraigned on an indictment of 5 counts, including second-degree murder, and that came as a result of a grand jury convene. There's been great confusion we've seen about the difference here between a grand jury and a trial jury, and the two of those things could not be more different. First, the standard of proof is lower for a grand jury. They need to only determine probable cause, which is one of the lowest legal standards our system holds. They also do not require a unanimous vote by the jurors. The prosecution also has broad discretion in determining how to proceed and doing so by way of indictment. The grand jury process lacks a crucial and important role of our criminal justice system, and that is the accused and their counsel being present during. There's no opportunity to cross-examine any witnesses, and it is basically ran by the district attorney. The state's comment and reliance on this "we have proved to a grand jury" is mere rhetoric. It's used as an insurance to bolster a lopsided indictment. Comments such as this have no place in an actual court of law, where it is 12 individuals who unanimously decide the outcome of this case based on this highest level of burden of proof, which is beyond a reasonable doubt. Statements that have been used by the Kern County District Attorney in her press conference tend to invoke a tidal wave of emotion towards finding guilt, whether substantiated or not, and this will taint a local jury pool and could deny our clients a chance at a fair trial. It's odd that the office held their press conference, made a series of comments which both mis- and disinformed the public, then the following day came and requested a gag order to stop the defense from having an ability to make similar comments. This action is disingenuous, but may also cause change for a change of venue in the future. It is now when the misleads and theater end and the constitutional protections begin. The safeguards of the accused and the fight to preserve those for Trezell and Jacqueline West begin now.
So the question is, did they cross the line, the district attorney? She came out and announced the indictment. I mean, the indictment is what it is. I mean, it's an accusation. She didn't get into any of the details of the case. She was extremely careful and precise. And the defense comes out and says it's not fair. Let's bring back in the think tank. What's your take on this, Randy? Is this a sign of strength or desperation from the defense, where they're going after the DA for announcing the indictment that they proved the case to the grand jury?
If I didn't know better, I'd say you used to be a prosecutor or something in a former life, Benny. You know, you might as well use air quotes. You know, while the defendants are presumed innocent, the way she said it was as if she didn't believe it. There is a presumption of innocence, and she didn't convey that there's a presumption of innocence. She made a mockery of that. I wouldn't be surprised if she's brought up on sanctions or brought in line before the bar. Are you kidding me? She also, to come out and say, well, we've gotten an indictment, that means that they're guilty. That's basically what she's saying, which is not what it means. It means there's probable cause. You might as well next time say, well, the police arrested the guy. He must be guilty because the police saw fit to arrest the person. You know, I think she crossed the line by a long way, not just a little bit over. I think she was far over the line.
And
my
Bremner.
You know, I can see that. I was just thinking when I was a prosecutor one time, I asked the jury, they kept raising the and I was a young lawyer, and I said, do you think the defendant was like blown out of a cannon and landed in that chair? We just basically said, come on in, you're going to be tried for robbery. Of course, a mistrial was granted. But the fact is that they've got special duties as prosecutors. They can't just come out and say, you know, he's indicted, that means guilty, or I think there were other statements made in the case challenged. And under that old case of Shepard versus Maxwell, remember the fugitive was based on it. The defense can comment on the nature of the defense, a lot of latitude, and pretrial publicity generated through the prosecutor could be grounds for review.
Rick King, I've covered a lot of press conferences. This DA would not answer any questions, would not give any specifics. She basically told us what was in the indictment, which is a very public document, and that was it. That was it. It seems like the defense is upset that their clients have been charged with murder. And by the way, Rick, this is a very easy case for them if, in fact, these two are factually true. I mean, if they want to prove their case, the defense, it should be over in 2 minutes, because the allegations are that these children were murdered in September. It wasn't until December that these parents said that they were abducted or went missing, December 20th. And the prosecution says that happened in September. The children are 3 and 4 years old, Rick. Like, do you have one photograph of the kids from October or November or December? Maybe Halloween, maybe Thanksgiving, maybe a birthday, maybe just, oh, they're doing something funny. I mean, you don't have one picture of these kids alive in those 3 months? To me, I mean, the case should be done in 2 minutes if they're factually innocent.
But the reality is the case is supposed to be tried in the courtroom. And what that prosecutor did was she tried it
She announced the indictment. She's not allowed to do that?
You can indict, as you know, you can indict a brown paper bag. What she shouldn't have done is said that we proved it to the grand jury, because the word prove, and I am wholehearted. I think Professor Randy channeled his best Professor Sterling just now, because we talk about the due process that defendants are entitled to, and they're entitled to the presumption of innocence. And for the prosecutor to come out and said that they proved their case to the grand jury it's improper and unethical.
Well, I'll tell you what, Randy, to prove that they didn't kill these children, all they have to do is show me one photograph. I mean, you can go to any parent of a 3 and 4 year old and say, hey, do you have any pictures of your kids? You'll be there for 3 days rolling through every picture that they've taken.
So let's just keep trying to prosecute them in public, right? Let's just, the court of public opinion, you're going to get them found guilty. But,
Right.
Rick, we're bonded here, because you got to prove it to a jury within the confines of the law, not in front of a microphone with a bunch of people.
I get it. I get it. But if it's your children, by the way, folks, Randy should be the last person talking about this. Go on his Facebook feed, and you will see 10 gazillion pictures of his beautiful daughter. I mean, and the bottom line here, Randy, is that if you are a parent, a loving parent like you are, everyone's got a cell phone these days. If you go through Randy's cell phone, you're going to see, of course he does. Of course he does, because he's a great parent. I mean, if your child was alive, I could show you a picture from last week, the week before, at least one picture from 3 months. One picture for 3 months, and is all they have to show to prove this case.
I got you.
I'm going on a cyber vacation now. We got to be on social media.
But that's the bottom line, right? You've got pictures. We all have pictures of our children. I mean,
on behalf of my client Randy, I'm going to say that that's still for the prosecution to do. The three of us on this side of the square, we're criminal defense lawyers.
I get it. But if you've got someone who's factually innocent and you could prove it by showing one picture, just show.
Not my responsibility. That's not my responsibility.
All right, take a look, folks. We've got a big readiness hearing coming up May 13th in this case, and we've got a trial date set, May 23rd. We'll see if they're ready on May 13th for trial on May 23rd. It could happen. It could happen. It's California. I can't keep track of those trials out there.